Not everybody. I won't make everybody tell me their names, but will you stop and just introduce yourself if we haven't met personally on the way out? So I'm Leslie Gibbons, and I'm in the Personal Trust and Wealth Management Department. I've been with Union Bank for a long time now, 16 years. So that little girl that I had when I first started is now in high school. Time passes very quickly, which makes this topic so relevant. I have been in trust services for about 30 years now. I love what I do. Doug and I have the best jobs. We get to work with individuals like you, our clients, and prospects on their estate planning.
I'm Doug King again. I just started yesterday. No, I've been here for 15 years at Union Bank, and I'd say 9 of those now have been in the personal trust department. And before that, I was in the investment center. So that's one. And maybe just to put the personal trust department in perspective too. So the whole trust division, just put that all in perspective. You know, in the trust division, we have retirement plan services, college savings plan, corporate trust, retirement plan services, UIMG, or our portfolio management group, and the personal trust division as well. And in there too is our whole operations area. And just so you know, all the services that we do at Union Bank are all in-house. About the only thing that gets farmed out is the printing and mailing of statements. So we do everything in-house. And if you think about our trust division, it has roughly $15.5 billion in assets. And so we're not the small trust shop anymore. We're more of a good mid-size that can really compete on a regional basis. And in fact, we have customers all over the United States and even a couple abroad. Our focus is Nebraska, and Lincoln is our headquarters. And in case you didn't know, our whole trust campus is at 27th and Pine Lake. So that's where I call our trust campus. But we have a full trust office in Omaha now because we have 2 officers up there and an assistant and a portfolio manager that are in that office full time. And we do provide trust services in Kansas City. And we do have 1 trust officer down there now, Dan Beckens as well. So we're going to talk to you about estate planning 101 today. So what Leslie and I do a lot of is we talk to people about trust services and what we can provide to them and what value Union Bank can add either in portfolio management or estate planning. And today we'll cover the topic of estate planning.
Keep going.
Okay. So, you know, I'll jump back to this slide real quick and just make a comment. So when we do talk to people about estate planning, we do want to create some urgency in that estate planning process. I mean, you just don't know what's going to happen, and it's better if you have a plan in place and you just have it done. If you already have an estate plan in place, then have you reviewed it recently, or has it been examined? You know, just pull it out, look at it again, because you just don't know when that bus is going to come down the street, and it's peace of mind just to have everything planned and in place. You know, there's lots of examples of people who didn't have their estate plan in place. I mean, one that I like to give is Abraham Lincoln. He didn't have an estate plan in place. You know, the President of the United States running the country, and he didn't have his estate plan done. We had to have a Supreme Court justice settle his estate. It took 2 years and quite a bit of money to do that, and it was a little bit in disarray. So we can all do our part getting our estate plan done, not only to save on those expenses and just getting everything in shape, but it's what you're leaving everybody and the shape it's in. It can be a complete mess, or it can be, you know, organized and planned out as well. So starting on this process can cause people to get organized, which is a good thing. So, all right, so what is estate planning? And I'll just put it simply. It's really what you want to have done with your assets, both during your lifetime and when you're gone. So just simply stated, that's what estate planning is. And and, you know, you think of lifetime, well, there's lots of things that can happen in life. And to, you know, disability because of a stroke or Alzheimer's or dementia or something like that. So planning is part of that during life, but then also what happens to all your stuff when you're gone. So you think about all those things. Why is estate planning important? And you think of the common things, you know, you think about just the distribution of assets and also about taxes, which we'll talk about here today, so we make sure that you understand that. But really, I think estate planning is important because the things that you leave to people, and a lot of times that's family members and things, you know, it really says something to those people and what you leave them and how you leave them things. There's lots of different ways you can leave them assets. And so you can read a lot into an estate plan. You can read a person's love for their family, the care and, you know, what they're hopeful for after they're gone, and what they want them to accomplish in life, and how you either help them do that or maybe sometimes not be so helpful in that as well. So that's what, simply put, estate planning is all about.
Okay, so who needs to complete their estate plan? So we're all in different stages of this life journey. Some of us are out of college, freshly out of college, just starting a new job. Some of us are preparing for retirement. I'm closer to retirement than I am getting out of college. But during the whole life's journey, you need to be thinking about that estate plan. And there are certain parts of that estate plan that become very important. You know, that freshly graduated college student may say, well, I don't have very many assets. Why is it important for me to have my estate plan put together? But it's important because that young, adventuresome, freshly graduated student is skiing in Colorado and something happens. And now they're in the hospital and they don't have a power of attorney document. They don't have a power of attorney for health care, and they don't have a power of attorney for their financial matters. What's going to happen? It's their intent that their parents step in, but they're an adult now, and those documents aren't in place. So I tell everybody needs an estate plan in place, and Doug is going to talk to you about what those documents include. But no matter where you are in the journey, you need to be thinking about your estate plan. If you die and you don't have a will in place, you die what we call intestate. And the state of Nebraska has a will for you. You may not like that will. It may not be what you intend. It may not include the family members that you want your assets to go to. Or it may not include the charitable organizations that are very important to you. So you need to get your estate plan in place. And Doug said, it can be a little bit overwhelming to think, I don't even know how to get started. So our goal today is to give you just a few ideas on what those steps include. And first of all, you need to stop and gather some information, and I suggest just writing it down. I feel better when the list is made. Think about who those family members are that are important to you. Write down children, siblings, parents. Write down those charitable organizations that are important to you. And we're going to talk further about who you may want to carry out your wishes, both from a financial perspective as well as a healthcare perspective. Write that down. Inventory your assets. You know, that seems daunting to me. Oh, I've got a CD, and I've got a savings account, and I've got a checking account. There's a whole lot of good resources out, even on the internet, for a personal financial statement. Doug and I also have a spreadsheet that we're more than happy to send to you so that you can use. Document what your assets are. Go a step further. Document how those assets are titled. Are they in my name? Are they in my and my husband's name? And also create a column in that spreadsheet for who your beneficiaries are on that checking account, on that CD. So take the time and inventory your assets. You'll be surprised. You're better off than you think you are. plan for the disposition of those assets. Stop and say, maybe sit down with your significant other or by yourself and say, who do I want to receive these assets if something happens to me? Who are those important people in my life that I want to pass these assets on to? Who are those important charitable organizations? What happens if I had some customers who recently celebrated their 50th anniversary. They took the whole family to Hawaii. But he said, you know what, we're all scheduling different plane flights because if that one plane would go down, oh no. So think about what happens if my family all perishes together. We call this the doomsday provision within your trust. Who would you want to have your assets if that should happen? Take some time to consider that. And then think about who your team of advisors are. Who's your insurance agent? Who's your accountant? Who do you rely on to receive advice? Jot that down. And again, we're going to talk about who do you want to appoint as your fiduciary? Who's going to be your trustee? Who's going to be your personal representative? Talk that through with your significant other or by yourself and gather this information.
Okay. So let's dig in and let's just talk about the cornerstones of an estate plan. So a lot of people, I think, okay, estate plan, what is that? You know, what is that? Well, this is what it is. It's all of these documents. And I'm going to call these the basics of the documents. You can get really complicated and sophisticated in estate planning, and there's reasons to do that. But you know, as much as you can keep it simple, great. But we'll just go through these documents. That all of these documents make up your estate plan. So when people are talking about estate planning, it's the will, it's the trust, it's the durable power of attorney, it's the healthcare power of attorney, the living will. All those things make up an estate plan. And Leslie and I would say, if you only have one of those things, you don't have a complete estate plan. This makes up a complete estate plan. So if we think about the will, what does the will do? And who can tell me, when does a will go in place? Or when does it start happening? At what? At death. So it's not during your lifetime. A will takes effect at your death. But in the will, there's some really important basic information that goes in there. So Leslie's going to talk about ownership because ownership is a big deal in estate planning. And so anything that you own in your own name at your death will go through your will. And in your will, you're going to do several things. One, you're going to name a personal representative of your estate. And the old term for that is executor. The new term is personal representative. It means the same thing. But that's going to be somebody who is going to be responsible for paying all your final bills, doing your final income tax. They're going to have to be collecting all your assets that are in your own name. They're going to have to make an inheritance tax determination. They're going to have to, distribute all those things and pay all those taxes and close out the estate. So they have potentially a relatively easy job, but it can also be a very complicated job. And that's when you think about all your assets you've written down. I mean, you think of things like, is there a second home? Is there a farm? Is there a business that they own? Or are there just investable assets in a house? So you think about those things. And then you got to think about who you're going to designate as your personal representative and everything that's going to be involved. So does that person have the time, the flexibility, the expertise? Are they somebody you trust? Are they good decision makers? Can they make decisions? So, and will they, if there's multiple beneficiaries of the estate, will they be impartial? Or more importantly, will everybody look at them and have the perspective of them being impartial? So if you name an executor or a personal representative who is also an inheritor of your estate, That's a fine line to walk sometimes. So you got to think about all those things that go into that. So should that be an individual, or should that be a corporate trustee, such as Union Bank? That's what we do. We serve as people's personal representatives. So one, a corporate fiduciary is something they do every day. They know the laws. They have a process to get it done. They're going to do it efficiently, effectively. They'll make sure that no mistakes are made and that everything gets done properly, and they will be impartial. They're not going to inherit any of your assets, because if you have a lot of beneficiaries and you name one person to be in charge of everybody's inheritance, sometimes that goes well and sometimes it doesn't go well at all, because greed and grief are a bad combination. So personal representative, that's the first thing to think about with your will, along with all your assets and how you want them distributed, as Leslie said. Another important thing to think about is if you have minor children, then a will is who you can name the guardian of your children. So who do you want to raise your children if you're not around anymore? And so my case, I have 6 minor children, and I went and asked the people that we wanted to be our guardians if something happened to my wife and I. And in fact, I ask them every year just to make sure that they are still willing to do that. And the only thing I ever get back is, can we buy a bigger house? And I'm like, yes, we can buy a bigger house. So anyway, and that's important too. You want to make sure that that person that you name as the personal representative or guardian of your children, will they do that for you? Ask them too. So before you put them in there, it's not going to do you any good to put them in there, and they're going to say, no, I'm not going to do this. So that's why you also think about an alternate personal representative, a second alternate personal representative. You think of alternate guardians and second alternate guardians that go in there as well. So that's the will. Anything I missed there, Leslie? So
The only thing I'm going to add is, one of the things that Doug and I hear frequently is we're sitting across from a client, and they said, and they'll tell us, I'm here because of a family situation. We're now drafting our will, and my brother served as the personal representative for my parents. I don't talk to my brother anymore. And we hear that a lot because, as Doug just said, it is a huge responsibility to serve in that role. And you need to think very carefully who you name. Ultimately, your biggest legacy is for me, I want my kids to get along. So.
Yeah, Vicki Huff, our mentor, our predecessor in what we do, one of her things she always said is, we're really in the business of saving family relationships. So, all right, a trust. So, there's all different kinds of trusts out there. But there's GRATs, GRUTs, CRATs, CRUTs, special needs trusts, supplemental needs trusts. There's ILITs, there's all kinds of stuff that do different things. But if we just talk about the basics of trusts and what they do. So there's primarily 2 different types of trusts. There's a revocable trust and an irrevocable trust. So a revocable trust is something that you can create during your lifetime. You can be the trustee of the trust. You can amend it, change it any way you want. You can revoke it, do a new one. It's changeable, and it's the way you're the grantor, you're the author of the trust. Another term they use is settler, and you can be your own trustee during your lifetime. Another type of trust is an irrevocable trust or an irrevocable trust. That's also something you can set up during your lifetime, but you can't change it, although there's a caveat to that sometimes. You can't change it, you can't revoke it, you can't amend it. You can put assets in there, but they're not yours anymore. They now belong to the trustee of that irrevocable trust. And there's reasons people do that sometimes, and primarily it has to do with taxes a lot. If you're over, and we're going to talk about taxes, but if you're over the threshold of the exemption amounts, sometimes it's a good idea to get assets out of your estate so that you don't get the high tax rates at your death. And we'll talk about those. The other time we see that a little bit is mom and dad have the farm. It's been in the farm, the family farm forever. They don't want anything to happen to it. And so sometimes you put assets in there that if mom and dad need them at some point, they can't get them back. That's not always the best. You got to really think about it that when you do that. So, but those are just two examples of what, or a little bit more about an irrevocable trust. Also, a lot of times you'll see this in wills. You'll have also what's called a testamentary trust. So people may have a will, but they actually have a trust that's inside of the will. So the will doesn't go into effect until when? Death. So that trust never springs to life until that person passes away. We call that a testamentary trust. And if you think about it, it's also irrevocable because a revocable trust can become irrevocable. So if you create a trust during your lifetime, you're the trustee, you've created all the language in that trust, but some time down the line, you don't have capacity to make your own decisions anymore. Well, at that point, that trust becomes irrevocable. No one else can come in and change it. No one else can come in and revoke it. You can't make decisions anymore. So whoever the successor trustee lives by those directions that you left them in the trust. So a trust does several things for a person. One, any assets that you put in the trust will avoid probate. So that's one thing that a trust will do. Another thing a trust does is, in a sense, you can think of it as your umbrella, and all your assets can go under it. And you can control and manage those assets under one umbrella, under the trust umbrella. And if you think about that too, you can make changes to your trust document. And if something happens to you, the trust explains how you want those assets managed if you can't do them anymore, who they're supposed to benefit. Are they only supposed to benefit you? Are they supposed to benefit you and your husband, or you and your dependents, or you and certain children? You can say that, and that applies to all those assets then. The other thing that it will do is if you have beneficiary changes and things like that, you don't have to go to all those individual accounts and change all those beneficiary designations. You can just do it in the trust because the trust owns all those assets. So it can be a collection point for you for good management of assets as well. When should you think about a trust? I mean, you can think about it in terms of dollar amounts. I mean, yes, it is a little bit more expensive to go to the attorney and have them draft the trust rather than just a will. You can think about the complexity of your assets. So the more complexity you have of assets, maybe that's the reason to think of the trust. Maybe you're single, never been married, have no kids. It's another great time to think about a trust because you really need that backup successor trustee to help if you can't do it. And then if you do think about dollar amounts, that can play in there too. I mean, in our world, $250,000 is the minimum size trust that we're really looking to handle as a corporate fiduciary. We do handle less than that as well. But when you start getting to that $1 million range of investable assets, yes, you need to be thinking about a separate revocable trust for sure. But that's not a hard or fast rule. So when I talked about the will, you think about who your personal representative should be. It's the same idea with the successor trustee. So you can be the trustee during your lifetime, or you name another trustee or whatever, but who's the successor trustee? Is that a family member, or a trusted individual, or is it a corporate fiduciary like Union Bank to serve as the successor trustee for all those same reasons that we talked about with the personal representative? So, yes.
When you were talking about the $250,000, is that cash on hand? $250,000, is that the assets?
No,
What, do you have to do a savings account, or Or is it-
savings, house,
Oh, the house.
investments,
Okay,
that.
all that,
So,
okay.
yeah, they can include all of that. So. Anything I missed on the trust lesson? So these next two things will go a little quicker. So the durable power of attorney. So unlike the will, it can take you need to assign someone to act as if they were you in all financial matters. And you need to decide who that is during your lifetime. A durable power of attorney for financial ends at death, and that's when the will kicks in. So during your lifetime, if something happens to you, or let's say you got to close on real estate, but you're going to be in Cabo, and you're not going to change your vacation, so you can say, hey, I named you as the durable power of attorney. You need to go to the real estate assignment form. So durable power of attorney for financial, you appoint somebody to act as if they were you in all financial matters. So you can make that an immediate power right now when you sign it. There's sometimes that people will do what are called springing powers of attorney. So until your disability, the power doesn't go into effect. So you can do durable power of attorneys in different ways. I think what Leslie and I have talked about is whoever you're naming in that position, you need to trust 100%. So we get things like, well, I'm not going to make them the durable power of attorney now. They may go in and clean out my bank account. I'll wait until I'm incapacitated. No, you don't put somebody in there like that if you can't trust them. So you can think about individuals as your durable power of attorney for a financial. I would say a corporate fiduciary or a union bank can serve as your durable power of attorney as well. We consider it a temporary document as we need to move assets around primarily, get it into a trust. We treat it as a temporary document. An individual may treat it more as a permanent document. I mean, they need to serve from this for as long as they need to until that person might pass away. So that's what the durable power of attorney for financial will do. You need, if you cannot make your own health decisions, and also this is giving the agent that you name as your durable power of attorney for health care, you need to give them the authority to get information on what's going on with you health-wise. You need to give them the authority to get that information. But you also need to give them the authority to make health decisions for you if you are not capable of doing it yourself. And this is not necessarily life-threatening situations, although they can have a say in that. Life-threatening situations, then we move to what's called a living will, or health directives. That is your directions to the doctor on how you want end-of-life matters to go. And that can be incorporated in the healthcare, in the durable power of attorney for healthcare, or it can be a separate document as well. So there's the nuts and bolts of what an estate plan is, and it's a complete estate plan. And Leslie and I always say, unless you have all this done, you don't have a complete estate plan. It takes into consideration everything.
And I'm just going to add, many times a client will sit across from me and they'll say, well, what do most people do? And it's a valid question, but it's an individual decision. And like Doug said, you have to be able to trust that position, that individual. But typically, we see you name a spouse as your durable power of attorney, and then maybe Union Bank as the successor. And I will also add, as you're considering naming somebody, if it's an individual, look where they're located. Are they located close to you? Naming your son who lives in New York might not be the best answer because your assets are here, you're here. Those decisions need to be made here. So that's something else for you to consider. Okay, so ownership and asset transfer. Doug has spoken about all of those documents that make up a good estate plan, but there's another step, and it's ownership and asset transfer. And your estate includes all those assets that you have right title or interest in. And our goal is to avoid probate if we can. Probate is a legal process. It's a court proceeding where the court decides who the rightful heirs of your assets are. Probate is also a matter of public record, so you need to be aware of that. So then we need to pause again and say, well, what are my assets? What are my assets and how are they titled? Those assets that you own individually are subject to probate and will go through probate if you don't have them titled and the beneficiary designations right. And you want those to coordinate with your will or your trust. And Doug just said those assets that are part of your trust avoid probate. But let's talk about the different ways that we can title assets. So the first one is in sole ownership. So I own my home, and on the deed it says Leslie Gibbons. Doesn't say anybody else. I'm the sole owner of that home. I pass away, my house now is looking for the next rightful owner. It's going to be subject to probate. Now let's say I own that home. I own my home with my husband Brian, and we own it jointly with rights of survivorship. I pass away, my husband now owns 100% of that home. That home is not subject to probate. Now let's say that I own my home with my husband as tenants in common. I own an undivided half interest in that home, as does my husband. I pass away, my husband still owns his undivided half interest, but now my portion, my ownership in that home is looking for the next rightful heir and will be subject to probate. Now think about this ownership, this titling on all of your assets. Think about it on your checking accounts. Think about it on your savings accounts. Think about it on your investment accounts. How are those titled? And then stop and say, who are the beneficiaries on those assets? I'm pretty sure that I drive the retail side of our bank crazy, because I'm telling my client, we'll go down and get a new signature card and put the beneficiary on that signature card, and they say, well, tell me exactly how it should read. So you can also put, and this is a very important part of those beneficiary designations, you can put a payable on death designation or a transfer on death designation on your assets. So now let's go back to those scenarios we just talked about. I have a checking account here at the bank that's in my name and my name only. But I have put a payable on death designation, whether I've put it to my children or I've put it to my trust. That asset now avoids probate. I can do the same thing with a transfer on death. Typically, you'll see a transfer on death on those securities, on those investments that I've got. And I can do the same thing. At my death, I want that account to transfer to my children, or I want it to transfer to my trust. This is such an important part of estate planning, and it's where people can not complete the process. So they've gotten their wills, they've gotten their trusts done, but now we need to go to the next step so that those assets end up in our trust at our death. Maybe we pick them up, maybe I put that investment account in the Leslie Gibbons Revocable Trust. It will avoid probate, it's titled that way. But once we do those documents, we need to make sure we go to the next step. Then we need to review that on a frequency that is appropriate for you. But for me, that's just something I do in the holidays every year. Maybe during the year I opened up a new investment account. Let's add it to the spreadsheet, make sure it's titled appropriately, and make sure that the beneficiary designations are as I would want them. So review those assets, review those beneficiary designations on a regular basis.
I missed something very obvious when I was on trust. I'll just go back to that. So you pass away and you have these assets. How do you want to handle it? Who's the beneficiary? So if they're minor children, you set up a trust to continue years, so that provides for those minor children for whatever needs they may have. And you designate a trustee to handle those assets, provide for whatever needs you want to provide for. The other thing you think about sometimes too is, and we get a lot of this, is parents who have children with special needs or they're on public assistance programs. You don't want to jeopardize those programs that they have. So you can't just dump a bunch of money and then it kicks them out of their government assistance programs. You need to set the trust up so that it supplements, doesn't take the place of the public assistance that they're getting. Maybe there's one child who is gone through bankruptcy and has creditors after them, or just hasn't been very responsible with their money. You can protect those assets for that child in a trust after you're gone. And there's language we look for to make sure that you protect those assets and they're not subject to creditors and all those things. That's where it gets really personal on how you want things handled after you're gone. So I didn't mention that, but I wanted to point that out. So, all right, so let's talk about taxes real quick, because this is always a question. And the way the laws read right now, they're pretty favorable for 99% of us. So really, there is a federal estate exemption amount of $5,450,000, and that's per individual. So for a couple, in order to have a federal estate tax assessed against you, which could be 40% and more, you would need to have more than $11,900,000. So that affects less than 1% of the population of the United States. But here in Nebraska, it can happen with real estate prices on farm property and things like that. So we have the less than 1% in Nebraska and people that we work with too. So, but it's just something to think about. And then the law says it's indexed for inflation each year. So last year was 5.43. This year was 5.45. So we'll see what it is next year. So, and we'll see who gets elected. Trump wants to do away with it completely. Hillary would like to bring it back down to 3 million. So that's where they're at on that. So then we used to have a state tax, and there's just a few states that have that anymore. We don't have it anymore. We repealed it in 2007, so you don't have to worry about that. So for most of us in the room, what are we left with? I'm going to call them death taxes. We're left with the inheritance tax. So there's 3 classes of beneficiaries. There's a class 1 beneficiary, which are immediate descendants. I mean, that's the family line, right down. So class 1 beneficiaries are subject to a 1% inheritance tax that gets paid by the estate. Each beneficiary gets a $40,000 exemption, and then above that, it's 1%. Class 2 beneficiaries will be aunts, uncles, nieces, nephews, blood relatives that are not on the immediate lineal descendant line, and they're subject to a 13% inheritance tax, and they get a $15,000 exemption on their assets. Then there's a class 3 beneficiary, and those would be all non-blood relatives that you may leave money to, and that inheritance tax is 18%. So that's important. This is where good estate planning comes into play, because we have lots of situations where a younger individual befriended a elderly person next door, and you know what? That elderly person really treated them like their own child. They didn't have any children of their own, and they really treated them like their own. Well, the law says, if you say that in the document, say this elderly person leaves this befriended person for years, and they've developed this relationship, and they really treat each other like mother and daughter. If you say that in the document, I treated her as if she were my own daughter, that takes 18% down to 1%. So there's just things to know in estate planning like that. So just something else to know when we talk about getting rid of assets during our lifetime. So if I owned a share of Berkshire Hathaway, which is worth how much now? I don't know. 170,000. I don't know, something like that, a share. And so let's say I bought it at $10,000. So my cost basis is $10,000. And if I go to sell that during my lifetime for $170,000, I have $160,000 of capital gains that needs to show up on my income tax return. Likewise, if I say, well, I'm going to start giving those shares away to my kids during my lifetime, so I give it to my son, it keeps my $10,000 cost basis. If he goes to sell it, he owes that big capital gains. But if I wait to give that Berkshire Hathaway until I'm dead, it gets a stepped up basis. So now his cost basis is $170,000. He sells it, he owes no capital gains. And you think of real estate, parents who bought farmland for $500 an acre. Well, if they give that farmland away during their lifetime, it retains that cost basis of $500. If they wait until they pass away, and the new cost basis is $11,000 per acre, and then they sell it, no capital gains. So it's just something to keep in mind as you decide what to do with your assets. Gifting. You can give away $14,000 per individual per year to as many people as you want, and you don't owe any gift taxes. Now, and you don't have to report it, you don't have to do anything. You're just given that ability to do that. You can go over that, and there's reasons to do that, but you have to know that you could be subject to gift taxes, but you also get a $5,450,000 gift tax lifetime exemption. So, and that can be used in planning as well. So there's some information on death taxes.
And a common question that Doug and I get is, so I can give $14,000 to my son? Yes, and so can your husband. So the two of you, it's not combined. He can give $14,000 and I can give $14,000 to my children or whomever I want to give that to.
Leslie, is that taxable for the child or
It's not.
so for neither?
For neither. Yes.
Does it matter if it comes from a joint account?
Doesn't matter. Yeah. All right. So what Doug and I have provided you today are two handouts. One is the trustee comparison, corporate versus individual, and this will just kind of walk you through some things to think about as you decide who's going to be my fiduciary. Who am I going to appoint as that personal representative and trustee, and what skills they need to have in order to fulfill that responsibility. We've talked about a lot. I don't know how we're doing on time. Are we perfect? Good. But we want to answer. That's why I like working with you. But we want to make sure that we answer any questions that you have. So we've also provided you with a checklist that you can use that just goes over a lot of what we've talked about today. So estimate the value of your estate. Determine what your family needs are. Do I have children that have special needs? How do I want my assets to transfer upon my death? Choose a qualified estate planning attorney. We haven't talked about this yet, but there are many wonderful attorneys in our community. Some of them deal with family law, some of them deal with corporate law, and there's a number of them that deal with estate planning. Doug and I would recommend that you go to somebody who focuses on estate planning because they're up to date on current statutes and know what's going on within the industry. If you don't have an attorney, let us know and we can tell you, we can guide you towards those attorneys that we work with that we know create good documents. And in that process, we're also there to answer any questions that you might have. choose your fiduciaries wisely. Really give it some thought when you think about who am I going to name in those important capacities.
Honestly, is that fiduciary, it could be a friend, it could be, or in most cases, is it a relative that's a fiduciary?
You know, we've seen the whole gamut of people that, or corporate fiduciaries that individuals will name. So you'll either name an individual or a corporate fiduciary like Union Bank.
But the individual is a fiduciary.
Right.
So it doesn't, whoever is the personal representative or trustee, by law, they are a fiduciary.
Okay.
They have to act in the best interest of the
Of their
beneficiaries. Yes.
Okay, since you're talking about the corporate with the UBT, so if you would be appointed, then you would have fees and stuff, people should probably be aware of that, as to if they appoint that.
It's a great question.
Oh,
So,
who cares about those?
Banking, it's all about money.
so let's walk through that process. Let's say you create a trust. You're going to be your own trustee during your lifetime. But you think Union Bank as the successor. Many people think, well, do I owe a fee right away? You don't. You wouldn't owe a corporate fiduciary a fee until they actually step in. And your document will dictate when they would step in. Maybe it's at your incapacity, maybe it's at your death. And at that time, a corporate fiduciary is going to charge a fee. But I will tell you what we have found out is it can be much less expensive to name a corporate fiduciary than naming an individual, because when you name that individual, they're not experienced in the process. So they're going to be reaching out to these professionals in the market, like an attorney and an accountant and an insurance agent. And all of those are going to be charging a fee. This is what we do every day. So appointing a corporate fiduciary is an efficient way to go. And is a very cost-effective way.
And if we understand this, so we can see clearly what our something
Okay, that was gonna be my next question. Say if they're considering that, can they come and meet with you to figure it out?
Absolutely.
And ask those questions, and then before you decide what to do, I think.
So Doug and I meet with individuals who are at the first step in putting their estate plan together, all the way up to, I've done it, and now we're getting together with them on a regular basis to review that estate plan. So if you have any questions or thinking, who do I appoint, just call Doug or I, and let's get together and talk. You can come to our office, we can come to your office. We're very flexible on where we meet. Take a look at that titling and beneficiary designation spreadsheet. Make sure you understand how your assets are titled and the beneficiaries are designated.
Do you have any suggestions on where to do that for a 401k and IRA, that kind of stuff, to have that work properly?
So you're going to work with your attorney as you draft those documents, but there are many things that we want to consider when we look at retirement plan assets. And I'm going to get a little more technical, but there's good reason to name your trust as the beneficiary on your retirement assets. But if you do, we want to make sure that there are provisions within that trust so that it's what we call a see-through trust, so that your beneficiaries get the best tax advantage as those retirement plan assets are administered. So I would say it's best to talk to us individually about your situation as you look at your retirement accounts. And so that we can understand what your goal is for, say, your children or your spouse.
That's a really important thing, why your titling and beneficiary designations, you have to coordinate with your estate plan. Otherwise, everything is done.
Isn't it less costly for we as employees to, like, move a lot of money here? I mean, like, to have, like, personal trust and, I mean, isn't it, like, you have, like, 401k plans that are really long time, wouldn't it be less expensive to move it here if you're an employee than to keep it at Principal Group or
Yeah, it really depends on where those assets are and what fees are associated with previous plans maybe that you were involved in.
What
Okay.
investment program are they in someplace else? So we're really good at looking at statements, and we're really good at analyzing and telling you what you're paying there and what you would be paying here, so you can do a good comparison. And what value you would get out of it.
I sat with a client yesterday, and he's getting up there, but what he told me was the best thing I did when I retired was consolidate my assets. He said I wouldn't be able to keep track of all the different investment companies and financial institutions that I worked with before. So there's great value in consolidating your assets.
But the short answer is yes, it is better.
And the final thing that I want to tell you all is estate planning is never done. I know that's not what you want to hear, but you get those documents done and then life happens. So you need to pull those documents out at least every 3 to 5 years and take a look at them and say, okay, does this still achieve my ultimate goal? Maybe you've had grandchildren that are born and you want to provide for them and that wasn't in the trust initially. So as Doug and I work with our clients, we're sending them out reminders on a regular basis. Pull those documents out. Come on in. Let's talk about things that have changed within the industry and see if maybe an update is appropriate or if those documents still achieve your goals just as you want them.
And real quick, we would be remiss if we didn't introduce Nancy Reynolds, part of our business development team in the personal trust department. So she helps us with a lot of things. And just a few value-added services with a corporate fiduciary that you won't see with an independent is if you get your estate plan done, name Union Bank, or you're looking at naming Union Bank, you can review those drafts right along with you. We don't charge to do that. We're looking at it from an administrative standpoint. So if we're going to serve, do we have any questions or comments before you actually sign it? And then if you do name Union Bank, we'll keep a confidential file in our department, and we'll make sure that we keep up with you on a regular basis so that if something does happen to you, we're not stepping in cold and don't know anything about it. And also,